Hello everyone, and welcome to this video series produced by HK45, a guide to arbitration. My name is Sarah Grummer and I am the Secretary General of the HKIAC. And today in this video I'm going to talk to you about the advantages of HKIAC as an administering arbitral institution and Hong Kong as a seat of arbitration. Founded in 1985, the HKIAC is globally recognized as a preeminent arbitration institution for international commercial and investment treaty arbitrations. In this short video, we will discuss three of the reasons for this ranking. First, advanced arbitration rules. Second, an efficient secretariat and decision-making bodies. And third, state-of-the-art facilities. The latest iteration of HKIAC's administered arbitration rules was formulated in 2018. They embody global best practices to ensure that arbitrations are able to keep up with the rapidly developing way in which business is conducted. The rules include many innovations, such as increased use of technology, advanced multi-party and multi-contract mechanisms, provisions for emergency arbitrators, and various other cost and time-saving mechanisms. Some of the key developments in our 2018 rules include stronger provisions for multi-party disputes and complex arbitrations. A stronger system for complex disputes eliminates the risk of inconsistent decisions and encourages efficient decision-making. The 2018 rules include 4 mechanisms for efficiently managing such disputes: single arbitration under multiple contracts, consolidation of multiple arbitrations, concurrent proceedings, and the joinder of additional parties. Each of these mechanisms allows for different scenarios that may arise in multi-party or multi-contract disputes. When commencing an arbitration, for example, a party may elect to commence a single arbitration under multiple contracts where parties are bound by multiple arbitration agreements and common questions of law or fact are in play. Arbitrations that are ongoing can later be consolidated if the parties agree or the claims are made under the same arbitration agreement, or common questions of law or fact arise in all the arbitrations. Arbitrations can also be conducted concurrently where consolidation or multi-contract proceedings may not be feasible. Finally, additional parties can be joined to the arbitration if they consent or are otherwise bound by the arbitration agreement. HKIAC's 2018 rules include provisions that allow parties to seek urgent interim relief prior to the constitution of the tribunal, and in some cases even before the filing of their notice of arbitration. When a party makes a request for an emergency arbitrator, HKIAC will appoint an emergency arbitrator within 24 hours, and the emergency arbitrator is bound to issue their decision within 14 days. HKIAC's 2018 rules include some of the world's most innovative measures aimed at reducing the time and cost of proceedings. These include a fee choice system where parties can choose to either pay the arbitrators a fixed figure based on the amount in dispute, or on the basis of hourly rates. This means that parties can choose the method of fees that is most cost-effective for their dispute. Second, a general cap on arbitrator hourly rates. Third, a cap on emergency arbitrator fees. And finally, the use of the HKIAC Tribunal Secretary Service, which allows HKIAC Secretariat members to act as tribunal secretaries for arbitral tribunals, allowing arbitrators to focus on the important matters without incurring high fees for administrative or secretarial work. The rules also include a time limit for delivering awards. Once a tribunal declares the proceedings closed, they must notify HKIAC and the parties of the anticipated date of delivery of the award, and that date must be within 3 months from the closure of the proceedings. HKIAC prides itself on maintaining a culturally diverse secretariat, including counsel and staff from all over the world and a variety of different legal cultures. The current HKIAC Secretariat includes multinational, multilingual individuals from civil and common law jurisdictions with experience in international commercial and investment treaty arbitration. The Secretariat is led by me, and we also work very closely with 2 specialist committees, which are nimble decision-making bodies and work with us on a daily basis. The first is the Appointments Committee, which deals with matters in relation to the appointment of arbitrators and the costs of arbitration. The second is the Proceedings Committee, which deals with procedural issues that arise in our cases under our rules, including challenges. HKIAC also has high-tech facilities offering a comprehensive range of virtual hearing services, including video conferencing, audio conferencing, the electronic presentation of evidence, and outsourced electronic bundling, transcription and interpretation, as well as a dedicated virtual hearing suite. HKIAC's video conferencing systems are IP-based or cloud-based and support multiple locations and are compatible with all major video conferencing platforms such as Zoom, WebEx, or Microsoft Teams. In the second part of this video, we will talk about the unique benefits of choosing Hong Kong as a seat of arbitration. There are many factors that contribute to Hong Kong's status as a leading seat of arbitration. We're going to talk about two advantages which are unique to Hong Kong. The first unique advantage is the legal framework in respect of arbitration between Hong Kong and mainland China. The respective authorities of Hong Kong and mainland China have entered into several arrangements to facilitate effective arbitrations. These are the Arrangement on Court-Ordered Interim Measures, which came into force in October 2019, and the Arrangement on Mutual Enforcement of Arbitral Awards, which came into force in 2000 and was supplemented in 2020. Under the Interim Measures Arrangement, parties to arbitration seated in Hong Kong can apply directly to mainland courts for interim relief. This is in the form of the preservation of assets, preservation of evidence, or the preservation of conduct. This access to interim relief from mainland courts is not available from any other foreign seat apart from Hong Kong. To obtain interim relief from a mainland Chinese court in support of arbitration proceedings seated outside of mainland China or outside of Hong Kong is very difficult and limited. We have seen the immediate, significant commercial benefit of this arrangement for parties, both mainland Chinese parties and foreign parties. The enforcement arrangement provides the legal framework for mutual enforcement of awards between Hong Kong and mainland China and functions in a manner similar to the New York Convention. Thus, it is crafted in line with global standards for enforcement. The second unique advantage in Hong Kong is its judiciary. The Hong Kong judiciary is widely considered to be pro-arbitration. By this we mean that it has regularly handed down judgments which support the effective and efficient use of arbitration in Hong Kong. Additionally, all arbitration-related court applications are set down in a specialist arbitration list of cases. The list is administered by a well-respected specialist judge with an immense amount of experience in arbitration. The advantages of this are apparent. Applications are dealt with efficiently and by judges who are intimately familiar with the requirements of arbitration. The Hong Kong judiciary upholds the rule of law through its common law legal system. It comprises local and international judges who are independent, professional, and efficient. Several judges in the High Court are former UK judges, and there is a rotating non-permanent judge on the Court of Final Appeal, Hong Kong's highest court, which ensures the independence of the judiciary. We hope this video has helped you to better understand the advantages of HKIAC as the administering institution and why Hong Kong is a unique place to arbitrate. The unique features of Hong Kong's position in the global economy and the dispute resolution industry make it the most logical choice when considering a seat for arbitration involving businesses operating in the Asia-Pacific region. Combined with HKIAC's innovative and effective 2018 administered arbitration rules, parties can rest assured that their dispute can be handled efficiently and professionally if and when the need arises. Thank you for watching, and I hope to see you in Hong Kong in the future.